who many of you probably don't need an introduction, but Makan Delrahim, you're a graduate of George Washington Law School. You worked at a number of firms and then were working on the Judiciary Committee. You have a close relationship with Orrin Hatch. You once represented or lobbied for the Ultimate Fighting Championship, which probably gives you a lot of good experience in your job now, which is that you are the antitrust chief for the Department of Justice, overseeing the recent Time Warner AT&T case and potentially leading us into other cases as future goes on. So let me start with a question, and we'll open it up at the end to questions you folks might have. But why shouldn't I believe that the government has dropped the ball by not going after any of the big tech companies so far? I look at Facebook, I look at Google, I look at Amazon, no antitrust suits.
So they have gone. Microsoft is a case from 20 years ago, and I was involved with that. The big tech companies, so one of the reasons is you actually have to have evidence that the law has been broken. And fortunately in this country, the Supreme Court has guided us that just being big is not bad. Being big, behaving badly is bad, because we don't want to punish somebody we've encouraged to compete. So you want to have the investors invest in big tech because they're providing the actual competition to the old line incumbents in a lot of industries. So I think you need to have evidence. I won't comment on any pending investigations us or the Federal Trade Commission may have, but there have been enforcement. There was dealing with the e-books a few years ago. The division has investigated that. There has been a lot of merger enforcements. And there's been some.
Facebook has an FTC enforcement or an agreement in place.
They do, and some of that relates to consumer protection and privacy issues, but some of that deals with antitrust. So, part of that is there evidence that a law has been broken? Has competition been threatened? And we're open to that.
So should we infer from the fact that there has not been any actions brought against the big platforms in particular, right? The 5 big companies in tech. Should we infer that they haven't done anything that has diminished competition in a potentially illegal or disturbing way?
What you should probably infer is that that the two agencies, from what is public, have not had the credible evidence to show that there has been a violation of the antitrust laws backed by an economic thinking that would prove that there is a harm to competition. So I think that's what you can infer. It doesn't mean that there hasn't been a violation just because there hasn't been enforcement of certain drug laws or money laundering doesn't mean that there hasn't been that type of activity that might have occurred. But I would say that there hasn't been.
And let's talk for a second about the standard, because you gave a really interesting speech at the Open Democracy conference a couple of weeks ago, Barry Lynn's group, and you very eloquently elucidated the two standards that you bring to trying to determine if, in fact, an antitrust violation has occurred. You talked about consumer welfare, right? And you spoke of this as the antitrust consensus, and I'll make a caveat that in some circles, this is an antitrust consensus. In other circles, it's heavily debated whether these are the right standards to be using to evaluate if someone has broken the antitrust law. But the two standards that you mentioned are consumer welfare, that you have to prove that consumers are somehow being injured, particularly that they're having to pay higher prices, et cetera, and that it has to be evidence-based enforcement. So for my sake and the audience's sake, walk us through that. What are those standards? What do they mean in practical application?
So, and part of that is, sadly, I don't make those standards by which we enforce the laws. The Supreme Court has over the number of years, and about 40 years. And groups, from all walks of ideology, from the American Antitrust Institute, who probably until the Open Markets Institute came about was probably as far to the pro-enforcement side of ideology, to the Cato Institute, which doesn't believe there should be any enforcement of the antitrust laws. All generally agree. So what does that mean? It means that, and the courts have guided us, that we have to show that a practice, or a merger for that matter, actually harms competition. So it doesn't, not that you're going to protect a competitor. So a competitor can't come in and say, hey, we're getting killed by this guy who is more efficient and can produce a product cheaper than me, because the consumer benefits, and that's the test. Ultimately, we want to take a look to see if the market is free enough where ultimately the prices will go down and the businesses are more efficient, meaning that the output will go up. And so there's a very rigorous economic test that sometimes we win, and as some of you saw in the AT&T case, we lost despite having Carl Shapiro, who is one of the foremost economists at Berkeley, twice served as the chief economist of the Antitrust Division in both Clinton and Obama administrations. But sometimes you don't win.
And I'm going to come back to AT&T, but let me ask on this, because one of the, since Robert Bork, since consumer welfare and particularly price has become a determining factor in these suits, we have seen that the ability to bring down prices usually means that consumers benefit.
Yes.
In today's age, many of the products that companies sell where we're concerned about monopoly, they give them away for free, right? I pay nothing to search on Google. I pay nothing to use Facebook. I pay nothing, I pay a little bit to Amazon, but they tell me that I'm getting the shipping for free, so it sort of feels like free. How in this age, and I know you've said you feel like the laws are robust enough, the laws don't need to change, how in this age should we interpret consumer welfare in an industry and economy where so many things are being given away for free? We don't have prices to give us information.
So in some new business models, as we're seeing now with some of the larger platforms, we need to begin thinking about what does it mean, are the network effects that are provided. And it's something that 20 years ago, the division was faced with in Microsoft. You might recall when Joel Klein and the Antitrust Division brought that case, and when Orrin Hatch opened the investigations in that in the Senate Judiciary Committee, it was not a popular thing. There was half the industry and Microsoft and a lot of folks who said, hey, they should be free to innovate. And that was the moniker, free to innovate. They should be able to do all these things to improve the operating system and the browser. And that antitrust is too antiquated to deal with all of these new technologies and the new business models they were providing because the browser was free. A unanimous DC Circuit Court of Appeals ended up upholding the antitrust findings that the district court found in that case and confirmed the problems. You just need to have, I think, the test that shows there's actual harm to the competition. So in the free markets, an example, who is being harmed by Google providing a search to you for free? And that is the ultimate test. And if they're giving away something for free, aren't you benefiting from that? Should we ask you to pay for that in order to avoid some other
Well, what about
harm?
other companies, right? Because when it comes to Google, we've seen a lot of claims that Google is disadvantaging other companies, not necessarily consumers, right? But in the aggregate, in an environment in which there's not enough competitors, there's not startups who can challenge what have become these entrenched giants, is there an argument to be made that Google, by precluding other companies from succeeding, by changing search rankings, that it, in fact, is eventually hurting the consumer in a way that deserves attention?
So not speaking about Google or any particular company, the real test there is, are you using your market power that you have earned in a particular market? So that could be search engines. Microsoft was the operating system. Are you then taking certain actions that would harm a threat to that market power? Microsoft was, for the very first time, the application programming network effects you had competition to that. Why? Because of Mark Andreessen and Netscape and Java, they were creating the browser, which was becoming middleware. Now you can write to that middleware, and it didn't matter whose operating system you used, and it was a threat. And the evidence showed, in lots of emails and communications between Bill Gates and others, that their whole intent was to keep the browser from coming into the marketplace and creating competition. That was the antitrust violation. So the European Union has had several cases against Google. And in those cases, they have found, and they have a little different legal standard than we do, but are you using your power to disadvantage the competition, not disadvantage a competitor? So if there's another competitor that you're driving out of business because you're providing a more efficient system, product, and cheaper, the antitrust laws in the United States don't care. You go out of the business, fine, we have a new, more efficient producer, and the market will create a new competitor if the margins become too heavy because there's an incentive to come in. But if you don't have that, then what they are doing is not a problem.
So in classical economic theory and classical antitrust, since Bork would agree with, since the 60s and 70s would agree with you, I think one of the challenges that's being offered now, we've seen this in Lena Kahn's writing and in Barry Lynn's writing, is folks saying, look, you could have the fattest margins on earth, but in this current economy, nobody else, it's winner take all. No one else can emerge to steal those margins, to compress the margin down, to take advantage of the fat that's on the bone. So, and let me give you an example, if I could, because sometimes it helps. So let's say I started a company that wants to sell things online, and I decided to call it The Nile, just as a name that I'm pulling out of thin air. And let's say I sell books. I have a cost structure that lets me undercut every physical seller, because I don't have to deal with physical stores. Let's say that I go and I buy a grocery store called Whole Foodies. And on the day I buy, let's say I buy it for $13 billion. On the day I buy it, my market cap goes up by $15.2 billion. I'm actually getting paid by shareholders more than I paid for this to acquire the asset. And all the other grocery stores, they go down $32 billion. So they have a capital structure that's putting them at a disadvantage in comparison to me. Now, the Nile might not take steps to try and deliberately punish competitors. Mm-hmm. But are we seeing a situation there in a winner-take-all economy where structurally I become a monopoly that cannot be displaced even if 20 years from now I decide to jack up prices?
So the test for that will become, so there's again, the Supreme Court has a test in a lot of these. And in the sense, in perhaps a practice you're describing called predatory pricing, where I try to undercut you to take over the marketplace, and then I'm going to harm the consumer by raising the price. The test is, and there's a rigorous, again, economic test, where am I selling a product below a certain marginal cost? So if I am harming myself economically by doing that in order to take over market share, that is the first part. And then the second, and it's still okay legally. The second part is there a dangerous probability that I'll be able to recoup those losses? So let's say something costs me $5 to make, and it sells in the marketplace for $10. It costs me $5. Let's assume it costs others around the same. I start selling it for $3 each. So I'm taking a loss, but I'm doing that to gain market share from my competitors. The law treats that as fine because the consumer it still wins by $2 per item or by more than just a $2 because it would be sold for that much cheaper. It only becomes a problem under the antitrust laws if you can show that what I'm doing, I can drive out everybody out of the market, and the barriers to entry are such that nobody can compete, and then afterwards I can raise the prices above competitive. So let's say the competitive price is $10. I can now raise the prices to 15 or 13 or 12 after everybody is out and recoup all those losses that I've calculated. That is the economic test under which we have to operate under. And the justification for that is the consumer benefits. If I'm being stupid and selling things for cheap, it only is harmed if there's not going to be a competitor coming in.
So let me push back a little bit on this, because the standard that you've elucidated and the conventional wisdom, right now that is true.
And by the way, that's the Supreme Court going against what the Justice Department at the time proposed to the court.
Absolutely. And what we know is that very often in antitrust, we have seen revolutions in jurisprudence, revolutions in thinking, because DOJ or because regulators have said, look, I think that this theory needs to be updated. Right? I think a theory that worked in 1956 doesn't work anymore in 1972, and we ought to apply a different take on predatory pricing. Are we at a stage where your division should be going into court and hopefully eventually the Supreme Court and saying, you know what, the laws still work, but we need to reframe our thinking, because the thing about the Nile is that we don't know how high those barriers to entry are. We don't know. We know that they've been willing to lose money like crazy for the last 20 years, but 20 years from now, when it's impossible for anyone else to compete, when Walmart's just housing immigrant children and doing nothing else, we don't know what they're going to do. And so maybe we need a different theory on how we analyze these things.
We advance a new test for a legal standard when the economic thinking is advanced enough to be able to do that. We provide a test. So under the same laws. So under monopolization law, we advanced a test in Microsoft that they took. In the recent American Express case, which the Supreme Court handed down yesterday, it was a DOJ case where the prior division brought it against American Express for these terms they have with merchants called anti-steering rules, meaning a merchant who accepts American Express cannot now tell a consumer, hey, it'll be cheaper if you use Visa or MasterCard. Don't use American Express. Supreme Court shut that down yesterday. They said that's not a violation of the antitrust laws, despite what the DOJ, we did not seek Supreme Court review after the Court of Appeals overturned the victory for the Justice Department, because we thought it would be, it's not the right case to take to the Supreme Court. So we declined to take it. The state of Ohio, along with 19 state attorney general, did seek cert in an unusual circumstance because it was a DOJ case. The Supreme Court granted. We supported that. However, we advanced a test in that. And the test was, I was really concerned that the Supreme Court was going to come and basically say, this is the way you have to take a look at these two-sided markets. American Express argued that they're a two-sided market. They bring merchants and consumers together, and you can't look at these as two separate markets. We provided a test where American Express's practice, if they were able to show that it doesn't cause consumer harm and it benefits on both sides, will be able to survive. The test that was put forth by the states and by the DOJ before me was that no, it's an absolute. If you're looking at two sides, so let's give an example that is more relevant to the discussions, is Uber. Can Uber take a certain practice on the driver side because they think the more drivers you have, the more consumers you might have? And can you not look at the benefits on the consumer side? You only look at the harms and the price on the driver side. Our philosophy was, no, you need to look at this. It's one interrelated market. It's a new business model. And you can't stick your head in the sand and say, if you are raising the prices on whether the consumer or driver, it can't have an effect. And it could be a positive effect because a Lyft can do the same thing and now be able to compete better with an Uber or whatever the next one would be. I was more worried the Supreme Court is going to come down with a test that would actually cause harm to new business models like Airbnb, Uber, some people would argue eBay and others that create these two-sided markets. And that would have a greater harm to our economy than losing this particular case with a particular test. So that's an example where you have to take a look at the economics and the pro-competitive effects.
And just for the folks who don't know, the decision that came down yesterday is actually a huge deal. In fact, Ina, who's here, I was just reading your update this morning, and was saying that all of Silicon Valley is really talking about this, right? Because it determines whether some companies are going to be open to antitrust or whether not. Let me ask a question to the audience really quickly. Sure. How many folks in this room feel like big tech is too big? It's too powerful. That these are monopolies that ought to be reined in somehow? Okay, about half. And how many people don't? How many people think fewer, but a good mix? So let me ask you this. For the folks in this room who are worried about big tech, is antitrust going to be the answer? Right? There's concerns over privacy in Facebook. There's a lot of concerns around a lot of things. There's a lot of concerns for small companies that are trying to compete on Amazon or trying to compete on Google. Do they need to look somewhere beyond your department for a bright future?
Well, hopefully, if you have vigorous and timely antitrust enforcement, and you have a court system that actually understands economics,
that's a pretty high bar that you're.
Well, and I don't mean the American Express case. I thought that was a sound decision, but you have a system of law where we have the burden of proof. We can't say this is good and this is bad. And we have to go to court, prove our case with a preponderance of the evidence standard, and win in a court. I think if that continues to go on and we protect the free markets, then there shouldn't be a cause for concern.
Really? Let me just challenge you a little bit.
Despite big, again, another, I don't know if it was Oliver Wendell Holmes or somebody like that, some years ago said, the competitor that we have encouraged to compete, once he succeeds, we should not turn upon them and say, you've succeeded too much. It's only if they have now stepped out and are causing other problems. And I think if you let that system go, look, you have many new markets. You have Google, you have Facebook that's come onto the market. I'm not saying it's easy to create a competition, but those are all new competitors. If there's a structural impediment and a problem, I think that's when the government should come in and fix it.
Do you think there might be, I'm not saying that there necessarily is, but given the economy that we're living in right now, might there be a structural problem?
People will have different personal views on this. And before the government should step in or could step in, there needs to be an actual empirical evidence of the structural problem. Where we've had structural problems, like in the telephone industry, Congress has stepped in and granted powers to the FCC. It's never good. In broadcast, we've seen major changes in the way TV is delivered, but we still have certain rules of how many people can watch a certain local news broadcast. I mean, I don't know how many people actually watch local television as opposed to cable and Netflix and Amazon and other mechanisms by which we consume our entertainment. But we still have those rules, and they become difficult to change. Why? Because the incumbents have so much power in Washington.
Absolutely.
They love to perpetuate it, and that regulatory system becomes a way to keep competitors from coming in because you don't want to challenge the current business model. Along the lines of what Professor Christensen wrote in Innovator's Dilemma. And so what we want to do is allow a marketplace that is free from regulation from new entrants. You want to have that, and that's at least my job. If there's going to be a broad policy debate in Congress to give other agencies powers to prescribe new rules. So maybe somebody comes in and says, look, you can't have more than 50% market share. Fortunately, we don't have that as a rule, but there's nothing that stops Congress from imposing such a limit in any industry.
So let me ask about a situation where you did think that there was a problem, which is AT&T Time Warner. Give me your take on, obviously the judge disagreed with you. What's your postmortem on that? What did you learn from that? B, do you think we should be concerned? Did His Honor not understand? What happened there?
Good question. I probably shouldn't talk about that because we're still determining whether we will appeal that ruling up to the D.C. Circuit Court of Appeals. One of my great heroes, who later was on the Supreme Court, was FDR's head of the Antitrust Division, Robert Jackson, who has written some phenomenal in all areas of the law decisions that should be an example for all of us. Said once that, the Supreme Court is not final because it's infallible, but they're infallible because they're final. District courts are not final, and they're not infallible.
Can I ask, what lessons did you learn from that trial?
We learned a lot. I mean, look, one of the things that was fascinating to me was in that case, the judge didn't seem to care and did not allow into evidence, documents and memos and PowerPoints created by executives of strategy and VPs and folks prior to the transaction, including the CEO's notes to the board justifying the transaction, which would have supported our case. However, the CEO's post-transaction statements on the stand were absolute truth and was a statement of fact for all throughout the 172 pages of the opinion, whereas because those were pre-merger transaction, I mean, those are the really probative documents, right? It's not the ones that have been scrubbed and sanitized by 11 of the world's most significant and substantive and powerful law firms in the world representing you to say, hey, let's take a look at this after. And in fact, one of the PowerPoints that was presented at trial said, this version has been approved by, they said, AG, which was Aiken Gump, and Cravath, which were the two of the law firms. Whereas just the immediate prior version of it said, hey, we got to do this because we got to keep the TV bundle together. Otherwise, we're getting a challenge from the cord cutters. At no point in this country's history have we had a defense to a merger that would otherwise be illegal, be that, hey, we can't compete because there's more efficient competitors coming into this business. We have this one defense called the failing firm defense, that if your business is failing, and even though you and I are the only two competitors in the market, the antitrust laws will allow me to acquire you to keep you from failing, because the presumption is there's not a loss of competition. But to say that, hey, our current business model is getting killed because consumers are going to something that technology has allowed them to do, like Netflix, like Amazon, like Hulu, like Sling, and therefore we need to merge to survive this erosion of our business model. Not that we're going to go do that. We might want to do that, but it's eroding that. That was fascinating to me in that decision.
Yeah.
And I hope it doesn't become something that other industries use, because that is the quickest way to kill new competition.
Before we got off platforms, because I have a couple of other things I want to ask you about. Let me just ask. We've talked about going into court, taking action, and you've spoken in the past that you do not believe in behavioral remedies, where you say you can go ahead and do this acquisition, this transition, as long as you promise really to be good and not try and take advantage of all the efficiencies this is giving you. Now, I've spoken to a couple of people in the FTC who have told me that they really regret letting Facebook buy Instagram, right? That they feel like what we haven't talked about is merger approval in the tech space. Do you think there should be more activity there? Should there be more attention brought to some of these acquisitions and mergers?
There should always be, particularly when you're looking at perhaps the only competitor that might be competing with that business. And is the acquisition, is it really to try to get 2 + 2 to be 5? Or is it really intended, I'm going to acquire this to shut it down because I don't like the competition they're providing? And those are some of the reasons we have 6 months, 8 months of an investigation. You look at documents, you look at emails, you look at the board memos, and see what was the original intent.
Right.
So it's not... I can't comment on any particular merger because it would be unfair. I don't have the evidence or the economics in front of me. But it's an important one to look at. On behavioral, I think we're a law enforcement body. You go in and you let the market decide. So if the deal is bad, you solve that portion of it with what we call a structural remedy, an asset divestiture and acquisition by somebody else in that market to preserve the competition. AT&T Time Warner was that. It wasn't that we had a problem with vertical mergers. In fact, we had no problem with Warner Brothers Studios being acquired by AT&T. We had no problem with HBO and Cinemax being acquired, and their whole library. Those are two of the most significant assets. Turner Sports and Live became a different issue because of the economics that we provided in court, and the judge seemed to ignore.
We're going to move to questions in 1 second. I do want to ask just a little bit about your background. You came to this nation as an immigrant when you were 10 years old, is that right?
Yeah, just before 10.
And you told me the other day that you were actually, which is a timely thing right now, you were separated from your mother for a while when you came.
And my younger sister for about 5.5 years.
5.5 years,
yeah.
That's a long time. Let me ask you, I think behind any conversation with anyone from this administration is the deep feelings that our current president seems to elicit. How do you feel serving for this president?
Look, I feel proud to be serving in this or any capacity. People will have different views. And sadly, we don't have the civil discourse that we should have. And people run into their corners, and it doesn't really matter. You can't be a pro-choice Republican or pro-environment Republican nowadays. because in the primary system you'll get crushed, and you can't be a pro-life Democrat or a pro-tax cut Democrat because your base doesn't allow you to do that. And some of the most important social issues that we deal with, public policy issues, are falling into those traps. And there seems to be not a debate to understand each other. And I wish there was more of that.
You've worked in all three branches of government. You've worked in the White House, you've worked in Congress, now you're working in an executive, and you worked in the courts for a little while. Given the breadth of the experience, why do you think that we are seeing this trending towards lack of civil discourse, towards lack of trying to find a consensus?
A couple of reasons, I think. One is the electoral system. I mean, the way we elect our local representatives, the redistricting processes by which my home state of California was one where for 40 or so some odd years, you basically had, Albert Berman's brother, who was kind of the senior Democratic member, and then you had the Republican side every 10 years sitting there in Sacramento drawing out the maps to protect the incumbents. Right. Talk about competition.
Can you go after that for antitrust?
Sadly, I don't think we can, but we would try. But they would draw out these maps that look crazy. I mean, I live in Malibu, and there's portions of it which, depending on high tide and low tide, you're in different congressional districts. Some of these slivers that were created was only created to protect an incumbent, which is why you have 94% of elected members reelected. Which, there could be, and there's a public policy reason why those things happen, but that's part of it. The other, I think, is more and more people want to listen to what they like. There's a lot of folks who voted the same way I did in 2016 who only watch Fox News or will only watch MSNBC. And the sad thing is, you don't have diversity of views, and so you're not seeing the other viewpoint from the other side. So it's much more difficult to understand.
And I have to say, it is we owe you a huge debt of being coming from the administration to this event, because this is a uniquely this year and under this administration, it's been hard to get folks from this administration, particularly pro-Trump Republicans, to come and share in the way that you are. So we appreciate you taking all those slings and arrows on behalf of everyone else. Let's go to questions, because I
haven't had any slings and arrows yet.
Yeah, so let's open it up. Go ahead, take your best shot. I am going to ask, if you don't mind, just make sure that you're asking a question as opposed to giving a diatribe. Yes, sir.
Thank you. I'm curious what you do with the concept of network effects today in antitrust litigation, where firms' services become more and more valuable and accrue more and more value to a consumer, but maybe the long-term competitive structure, as you were saying, is prohibitive to future startups or competitors.
That's a great question. So as part of our analysis, whether it's a merger or a monopolization case, we look at the barriers to entry and the structure of a particular market. So a network effect falls right into that analysis, and depending on that market, the greater the possibility and the likelihood of a network effect in a particular market, the less likely it is that, or the greater the bar for entry is going to be. So the competitive effects of entry becomes more diminished in some of those analyses.
Hi, Ina Fried with Axios. I'm curious, with the Amex ruling, are you concerned that the way it was worded will limit the antitrust enforcement's ability to, should it see a need to go after a Facebook or a Google, are you concerned that that ruling will make it tougher to do so?
Good question. I don't think so, for a couple of reasons. And obviously, it's, every single case is fact specific, it's evidence specific. One of the challenges that the court provides is that, in some markets, we have to take a look not only at price effects of a particular activity, and that case was a Section 1 Sherman Act violation that was alleged, but you have to also look to see if output would come down. which was something new that the court provided. But they also did mention the newspaper. So the credit card as a transaction platform, the reason you would have that transaction, but you would only have that transaction when you have a merchant and a consumer on both sides. Without it, there's just not a transaction to be had. And he said a newspaper, even though sometimes a newspaper is considered a two-sided market because you have viewers and subscribers and readers and you have advertisers on the other side. The court was careful to distinguish that because a reader does not go to the New York Times because of the advertising. You're going there to read the great articles that some of these folks write.
Or just to get angry for the day.
Or depending on the editorial board, you could get angry for the day. But or that could also go with the Wall Street Journal. They have been, the editorial board has not been kind to me. But it is, so that's an important test. The question is, do you go to Google to search because you like the advertisement that they sent to you? Or do you use it for a certain product? I would argue first part of that, the former, and therefore you don't benefit from the American Express case in that particular one. But the application is going to be important. But I think Uber or Airbnb might have a different analysis because you do have the driver and the rider, and that's where you have that transaction. And without two sides of that market, the network effects of one side onto the other is really important. And I think that, it would be difficult for certain practices. That doesn't mean Uber and Lyft can agree amongst themselves to set prices in a city. They'd go to jail for that. But in certain types of practices, I think it has an effect in some segments of the tech sector.
Sir, back here, you have a very nice beard, so I'm going to call on you.
Thank you.
Beards have to stay
Hi,
together.
I'm Makan. I'm Bob Rosenfeld from San Francisco. I've practiced antitrust law for 40 years. We've actually worked together.
Yes.
But my question is not really a sling and arrow, but it's in some ways a self-inflicted wound. You can't sit here and listen to this discussion without thinking that antitrust law has become a subset of microeconomics. And a lot of the discussions and so on are things that only economists could love. And yet, the origin of antitrust laws was not in the economics departments of our great universities. It was Teddy Roosevelt and Brandeis worried about the accumulation of excessive corporate economic power. And I think a lot of people that focus on antitrust these days are much more concerned about that aggregation of economic power than where the average variable cost curve intersects the revenue curve. And I'm just wondering, as head of the Antitrust Division, and I think you and I might even agree on that, but as head of the Antitrust Division, what are you all doing to think about the broader societal implications of the aggregation of economic power in these very, very large enterprises, whether they be tech or something else?
So the aggregation of power in any particular sector is important. Obviously, it plays into the analysis, whether it's a merger or a particular kind of a unilateral practice being practiced by a company. There was a recent report put out in 2016 by the Council of Economic Advisors that talked about consolidation and aggregation of market power. Sadly, I think that report suffers from a lack of some greater granularity in the sense that it doesn't look to the markets, the economic markets, but rather lumps in a whole bunch of industries. John Oliver did a great piece on HBO on this for about 17 minutes earlier, about a year ago, and it was hilarious and it was good. And some of the cases and companies that he cites in there, there's some valid, I think, concerns related to that. But we have to be careful looking at particular markets, specific markets that would have an effect ultimately on that consumer rather than just a greater consolidation. Look, is it difficult to go to court and win a case? The last 2 weeks has got to show you that. It is, for a number of reasons. Some of it is just structural with the Antitrust Division. I mean, the Antitrust Division, I think our budget for the whole division, which includes 40% is criminal, this is cartels and price fixing that we enforce. 60% is civil, of which maybe 10% is behavioral. The rest is mergers. Our whole budget is $165 million. We have 50 PhD economists, about 350 lawyers. AT&T case, consolidated into a 5-month case, trial and litigation. 700, at least by some reports, lawyers that worked on that case. Over $400 million in legal fees spent. The world's best, 112 registered lobbyists. God knows how many were not registered and were strategists. How do you, and they changed the public image talking about the fact that somehow I was challenging that transaction because of CNN, which the irony of it all is, which wasn't lost on the court, was under our theories, we say CNN should be more broadly distributed. And the argument was if you merge it, there's less of an incentive to actually distribute the Turner asset. So the argument fell flat, but a lot of people love to report on it and discuss it. So that was strategic, and it was smart in some sense. But it becomes a challenge for the antitrust enforcement agencies. Not a single state AG supported the transaction. I think that was largely not because they thought the transaction was legal. It's because I think they thought somehow they didn't want to support a Trump administration. One specific state AG, as a condition of joining our case, demanded that any divestitures as a part of a settlement through the trial cannot be sold to Rupert Murdoch. I mean, I just thought that violates the First Amendment. I couldn't agree to that because if we go down that road, what if it's the next one? You can't sell it to, Bob Iger, or you can't sell it to, who's the guy in California who's running the ads? Steyer. Tom Steyer. I mean, it just becomes silly, and it's not the way the government should be run. So those are some of the challenges we have in some of the big cases. That's not to mention the legal standards, where you have a judge who totally discounts, doesn't even allow into evidence certain very probative evidence that we try to offer.
One more question, Mr. Loren.
Listen louder.
Louder, sorry.
Hi. My question is about monopsony law. For those of you in the audience who don't know, a monopoly is when there's only one seller. Monopsony is when there's only one buyer. There are a number of problems with monopsonies, but there's very little enforcement against it. And the Cable Act of '92 forced the programmers, many of whom were owned by the cable operators, forced them to sell to the satellite providers, and that's what enabled the satellite industry to become a force. That act didn't actually create new law regarding monopsony. It just dealt with a monopsony problem in a way that I think was pro-competitive. But the issues of monopsony problems remain. And Amazon, for example, is being a much tougher negotiator for people wanting to sell on their platform over time, et cetera. So the question is, do you think that there should be more robust monopsony law to provide better guidance both to courts and to companies as to how to behave?
The good news is, under the current antitrust laws, we may not have some recent, I think it was one in the paper industry maybe about 10, 15 years ago or so, but we don't have as many recent cases to guide us further, but monopsony is just as much of an evil as it is a monopoly. We look at that when you have a lot of, in the agriculture industry, you have processors, and when they merge, are they getting to the size where they're causing monopsony harms to a farmer or a dairy farmer or somebody who wants to sell to them? So our analysis is the same. In the intellectual property area, that's been one of the areas that I've probably given, I don't know, half a dozen speeches to try to recalibrate, not only in the United States, but internationally, how we treat intellectual property. There's a school of thought that says that patents that are involved in our everyday products, the more we challenge them, the cheaper it might be because the consumer will get a cheap, if we lower their royalty rates that they can recover, the cheaper that product might be. In that snapshot, it might be true. But the problem is that it prevents the incentive to invest in that intellectual property that actually creates the next better product. It's not so much we want a cheaper Motorola Razr, it's that we want the iPhone. And that has made the consumer benefit a lot more, and we want the iPhone 20 or whatever the heck it will become in the next few years. In the standard setting business, where you have a group of users of intellectual property, the effect that it could have is that they will set prices. And that's an area we have been active in, and there's been a report about a significant investigation we have in the technology field, where a group of incumbents have gotten together to depress the use, but also the royalty rates of a new technology that could benefit consumers. But the problem is it would create more competition for them. They don't like that.
So one last question before we adjourn. We're at the Ideas Festival. We're supposed to be thinking big ideas. We're supposed to be exploding our brains. Makan, what is your big idea? What is the thing you want to leave us with that we should be thinking about?
Great question. And it is. And it's got nothing to do necessarily with antitrust, although it's a little bit informed by antitrust. And it probably would help address the earlier issue as far as civility in our public discourse we have. Some of our great antitrust cases at our Supreme Court has come from the lawyers, the American Bar Association, or lawyers banding together to try to keep competition out. In the United States, unlike any other country, to become a lawyer and provide legal services, you have to go to school for 7 years. You have to get a bachelor's degree and then go to law school for 3. And then you clerk and do other things to become useful. But we are a country of laws. We are a country of the Constitution. It is sad how few people actually understand some of our most basic elements. We require 4 years of a foreign language in college. God knows how many other years of French literature and other things that we've all read, which are all wonderful. But there's no requirement of understanding some of our most fundamental rights that as consumers, we would become better consumers, we would become more informed. As citizens, we would understand the government. And I would love to see, there's some wonderful foundations here. I would love to see that first year of law school, constitutional law, contract law, torts, and criminal procedure, talk about police violence and all of that, that to be a required course in 1 year at colleges around the country. It would be too ambitious to put them in high schools and maybe kids wouldn't understand them. But in college, if you had 1 year of your basic understanding of your government, constitutional law, you understood every time you sign a contract, you sign I accept on your apps, you don't become angry later, what the heck did I do? Or you actually care about what you sign or whatever it is. You understand that if you hurt someone or somebody hurts you, what are the limits and rights you have in torts and criminal procedure. When you get pulled over, what do you know? The rest of the stuff is, law is not brain surgery. We can all learn that. You can practice that. But could you just imagine what a better citizenry we would have? It's something I learned, coming from Iran, but I think probably appreciated in a different way than most who are guaranteed these rights. But when you understand your First Amendment rights, your rights to intellectual property rights, or whatever the heck it might be, and I would hope that sometime, whether it's the Gates Foundation or others, get together and create that. I think we would be a much better country.
Well, listen, thank you for your time. Please
Thank
go
you.
forth and fight giants.
Thanks.
Really appreciate it.
Thanks, Charles.